Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in Bestek versus Berryhill, Acting Commissioner of Social Security. Certiorari to the United States Court of Appeals for the Sixth Circuit. Argued December 4th, 2018. Decided April 1st, 2019. Petitioner Michael Bestek, a former construction worker, applied for Social Security disability benefits, claiming he could no longer work due to physical and mental disabilities. The Social Security Administration assigned an administrative law judge to conduct a hearing, at which the ALJ had to determine whether Bestek could successfully transition to less physically demanding work. For guidance on that issue, the ALJ heard testimony from a vocational expert regarding the types of jobs Bestek could still perform and the number of such jobs that existed in the national economy. See 20 CFR sections 404.1560 C1 and 416.960 C1. On cross-examination, Bestek's attorney asked the expert where she was getting her numbers from, and the expert explained that they were from her own individual labor market surveys. Bestek's attorney then requested that the expert turn over the surveys, and the expert declined. The ALJ ultimately denied Bestek's benefits, basing his conclusion on the expert's testimony about the number of jobs available to him. Bestek sought review in federal court, where an ALJ's factual findings are conclusive if supported by substantial evidence. That's 42 U.S.C. section 405G. The district court rejected Bestek's argument that the expert's testimony could not possibly constitute substantial evidence because she had declined to produce her supporting data. The Sixth Circuit affirmed. The Supreme Court held a vocational expert's refusal to provide private market survey data upon the applicant's request does not categorically preclude the testimony from counting as substantial evidence. Substantial evidence is more than mere scintilla and means only such relevant evidence as a reasonable mind might accept as adequate to support a conclusion. That's from Consolidated Edison versus National Labor Relations Board. Bestek proposes a categorical rule that the testimony of a vocational expert who refuses a request for supporting data about job availability can never clear that bar. To assess that proposal, the court begins with the parties' common ground. Assuming no demand, a vocational expert's testimony may count as substantial evidence, even when unaccompanied by supporting data. If that is true, is it not obvious why one additional fact, a refusal to request for that data, should make an expert's testimony categorically inadequate? In some cases, the refusal to disclose data, considered along with other shortcomings, will undercut an expert's credibility and prevent a court from finding that a reasonable mind could have accepted the expert's testimony. But in other cases, the refusal will have no such consequence. Similarly, the refusal will sometimes interfere with effective cross-examination, which a reviewing court may consider in deciding how much to credit an expert's opinion. But other times, even without supporting data, an applicant will be able to provide the strength of the expert's testimony. An applicant will be able to probe the strength of an expert's testimony on cross-examination. Ultimately, Bestek's error lies in his pressing for a categorical rule, applying to every case in which a vocational expert refuses a request for underlying data. The inquiry, as is usually true in determining the substantiality of evidence, is case by case. It takes into account all features of the vocational expert's testimony, as well as the rest of the administrative record, and defers to the presiding ALJ, who has seen the hearing up close. The decision below is affirmed. Justice Kagan delivered the opinion of the court, in which Chief Justice Roberts and Justices Thomas, Breyer, Alito, and Kavanaugh joined. Justice Sotomayor filed a dissenting opinion. Justice Gorsuch filed a dissenting opinion in which Justice Ginsburg joined. Thank you for listening. If you'd like to get a hold of the podcast, we can be reached at RhodeScholar80 @gmail.com. That's ROADS and 80.